Every case tells a story. My job isn't just to tell it, it's to help you recognize the warning signs before they become evidence in a courtroom. Let's get on one. A wife is convicted of murdering her wealthy husband. Not over jealousy, not over revenge, according to prosecutors, over money. A prenuptial agreement, an affair, millions of dollars, a fatal dose of fentanyl. Today we're asking one question. What happens when someone believes divorce costs too much? The prenup that was supposed to protect wealth became a death warrant. Most people look at a prenuptial agreement and see a legal safety net, a shield for assets, a sensible, if unromantic, insurance policy against a messy divorce. But in the case of the state versus Kouri Richins, that piece of paper wasn't a shield. It was a countdown. When they walked down the aisle, she signed a contract that dictated the exact terms of her future. If she walked away from her wealthy husband, if she packed her bags and filed for divorce, she left with nothing. Zero. No alimony, no mansion, no payout. Unless he died. Under Section 4, Paragraph B of that very agreement, the restrictions dissolved upon the husband's death. Suddenly, the penniless wife becomes the multimillionaire widow. Behind the closed doors of their pristine home, a quiet desperation was boiling. Prosecutors say Kouri Richins was drowning, suffocating under a mountain of hidden debt, and hopelessly in love with another man. She needed an exit door, but divorce was a financial suicide mission. So she looked at the contract and found her a loophole. It didn't require a lawyer, it required a lethal dose of street fentanyl, slipped quietly into a late night drink. Today, we're pulling back the curtain on a case where the most explosive evidence isn't found at the crime scene. It's found in the legal documents, a prenuptial agreement, an estate plan, millions of dollars. Was this a calculated plot fueled by financial motive, as prosecutors alleged, or a tragic accidental overdose? Let's get on one. Okay, let's dig a little deeper into the facts of this case. Okay, so with the prenuptial agreement, we've got two scenarios. Scenario A, divorce. If they break up, she leaves with nothing. No alimony, no division of assets. Scenario B, widowhood. He dies while they are married. The prenuptial restrictions dissolve and she inherits his estate, life insurance, and massive designated payout. For a woman under intense financial pressure, that piece of paper effectively closed every exit door except for one. Okay, here's the setup. The couple, Eric and Kouri Richins, they married in 2013, living in an affluent Utah suburb with their 3 young sons. Eric was a highly successful self-made businessman who owned a masonry company. Kouri was a real estate investor who flipped houses. His sudden death on March 4th of 2022 in his bed. The toxicology report later revealed he had 5 times the lethal limit of synthetic fentanyl in his system. He had absolutely no history of drug abuse. A year after his death, Kouri self-published a children's book titled, Are You With Me? It was written to help her 3 young boys cope with the sudden loss of their father. She even went on a local television show to promote it as a grieving widow. Just weeks after her media tour, Kouri was arrested and charged with first-degree murder. Imagine that, writing the book on how to survive grief and then being arrested for causing it. Why would a mother of 3 do this? The prosecution's case boils down to a deadly cocktail of financial desperation and romantic betrayal. Kouri's house flipping business was in catastrophic debt. She was drowning in millions of dollars of unpaid hard money loans. To keep afloat, she secretly forged Eric's signature to take out a $250,000 line of credit and stole money from his accounts. She also had a secret romantic relationship with another man for nearly 2 years leading up to the murder. The prenup catch-22, before they married, she signed this prenuptial agreement. If they divorced, she practically got nothing. No alimony, no division of his business. But under the contract, if he died while they were married, his multi-million-dollar share of the masonry business would be transferred to her. Okay, let's dig a little deeper. On Valentine's Day, weeks before his death, on Valentine's Day, okay? Kouri made Eric a sandwich. After taking a bite, Eric broke out in hives, couldn't breathe, and had to use his son's EpiPen. He survived, but he told his friend, "I think my wife is trying to poison me." Now, on the night of March 3rd, 2022, she brought Eric a celebratory glass of Moscow Mule to toast a closed business deal. Within hours, Eric was dead. Okay, here's the massive twist. Eric knew Kouri was stealing from him. In 2020, without telling Kouri, he secretly met with an estate planning lawyer. He transferred all of his assets and life insurance into a private living trust and named his sister as the trustee. So at the time of trial, the prosecutors had three motives for why she would do this. Every criminal case tells a story. This is the story the prosecutors asked the jury to believe. Whether you agree with it or not, it helps explain how they connected the evidence. Number one, financial pressure. According to the prosecution, the marriage was under significant financial strain. The evidence presented included mounting debt, substantial withdrawals, credit card spending, a failed business by Kouri, and increasing financial obligations. The prosecution's point wasn't simply that money was tight. It was that the financial pressure had become overwhelming. Number two, they said she had already moved on. Prosecutors presented evidence that Kouri had emotionally distanced herself from the marriage. They pointed to communications and interactions with another man as evidence that she was already envisioning a different future. But according to the prosecution, there was one problem. Getting out of the marriage through divorce allegedly came with serious financial consequences if the prenuptial agreement was enforced. So here's the alleged plan. Prosecutors tied together digital evidence, witness testimony, and toxicology findings to argue that this was not an accident, but a deliberate act. Their theory was that financial pressure, dissatisfaction with the marriage, and the prospect of a difficult divorce converged into an alleged plan that ended in death instead of divorce. As a family law attorney, that's the question that captured my attention. What would divorce have actually looked like? Would the prenuptial agreement have been enforced? Were there legal options that could have changed the outcome? That's what we're going to unpack today. Because no matter how difficult the marriage, no matter how painful the divorce court will do. Let's dig a little deeper into the prenuptial agreement. The key provisions established in their 2013 prenuptial agreement included separate property and income. The core of the agreement mandated a strict separation of assets. Both Kouri and Eric relinquished any present or future rights, titles, or claims to each other's individual income, personal property, or independent assets accumulated before or during the marriage. Then there was this business exception clause. This specific clause became a focal point for the prosecution's motive theory. During marriage, any business established individually by either party remains solely their separate property. Eric's highly successful stonemasonry business and Kouri's later real estate flipping ventures were entirely separate. Under standard divorce terms, neither could claim the other's business. Then there was this death provision. The contract contained a critical exception. If Eric died while the two were still lawfully married, his interest in his stonemasonry business would transfer to Kouri. Okay, so what would this divorce have looked like? As a California family law attorney, this is the question I kept asking myself throughout this case. If this marriage had simply ended in divorce, what exactly would the process likely have looked like? First, the testimony at trial indicated that Kouri was overwhelmingly concerned about losing her children. In California, absent evidence that a parent is unfit or that another circumstance would justify a different arrangement, courts generally favor frequent and continuing contact with both parents. That often results in some form of shared custody, although every case turns on its own facts and the children's best interest. Second, if a valid prenuptial agreement existed and was ultimately enforceable, the court would generally enforce its terms. Based on the facts presented at trial, that could have meant the following for Kouri. Eric would retain his separate property business. Eric would retain his separate property residence. His life insurance and estate plan would be governed by the applicable legal documents. Kouri would remain responsible for obligations allocated to her under the prenuptial agreement, including her own debts, which was estimated to be almost $8 million. The waiver of spousal support would likely be honored. Would those terms have been financially difficult for her? Probably, possibly. Testimony suggested she had a failed business and significant financial challenges. She may have had to drastically change her lifestyle. She may have needed family support while rebuilding. She may have even considered bankruptcy if her financial circumstances warranted it. None of those outcomes are easy, but difficult doesn't mean impossible. And because they shared children, child support would have still been analyzed separately. In California, child support is based on statutory guidelines that considers factors such as each parent's income and custodial timeshare. A spousal support waiver in a prenuptial agreement does not eliminate a parent's obligation to support their children. Depending on the parties' incomes and parenting arrangement, child support could still have been payable. Okay, so let's talk about these red flags. One financial incident, maybe it's a mistake. Two, that requires a very difficult, very uncomfortable conversation at the kitchen table. But when the warning signs keep flashing, eventually the question isn't whether the red flags are there. The question is, are you willing to read the writing on the wall? In the Kouri Richins case, the writing wasn't just on the wall, it was painted in neon. Look at the pattern. It started with what I call the invisible bleed, hundreds of thousands of dollars vanishing. First, a $250,000 line of credit taken against his separate property home without his knowledge. $100,000 pulled directly from his personal bank account. Then she racked up $30,000 on his personal credit card. Then she drained his business account, $134,000. And of course, there was the classic, a promise to pay it back, but that never really materialized. Then the pattern shifted. It went from draining his past to betting on his future. A life insurance policy quietly changed to make her the beneficiary. When she got caught, she changed it back only because she realized it wasn't his policy to change. So what does she do? She goes out and gets a new $2 million policy. And finally, the pattern that crossed a line that can never be uncrossed. The physical warning. A Valentine's Day sandwich, followed by him breaking out in hives and needing his son's EpiPen. A chilling confession from Eric to his friend. I think she's trying to kill me. Here's what stands out to me as an attorney and as someone who guides people through the darkest chapters of their lives. Kouri Richins wasn't blind. He recognized something terrible was going wrong. He didn't just sit there. He confronted her about the missing money. He questioned the circumstances. He confided in his circle. And then he took massive, decisive legal action. He met with an estate planning attorney. He created a protective trust. He stripped her as his beneficiary and named his children. He appointed his sister as trustee to guard the gates. He recognized the financial risks. He saw those red flags and he took steps to protect his legacy. But no legal document, not a will, not a trust, not a prenuptial agreement, can protect you from the wrong person. There was one moment during this trial that stopped me in my tracks. It wasn't a forensic expert. It wasn't a toxicology report. It wasn't even a text message. It was the demeanor of her affair partner on the witness stand. The courtroom watched as the man whom she carried on an affair relived their relationship one text message at a time. The courtroom was still and quiet. You could hear a pin drop as prosecutors slowly and painfully walked him through text message after text message. I love you. I miss you. I can't wait to see you. You could see the emotional weight of those words settle over the courtroom. At one point, the judge paused the proceedings so that her former lover could take a moment to compose himself. He wiped away tears. He appeared in sheer agony. He lowered his head on the witness stand more than once. At another point, he turned his chair around, overwhelmed. Whether the jury interpreted that as grief, regret, guilt, heartbreak, or something else, that was for them to decide. For me, it was a reminder that criminal cases don't just leave behind one victim. They leave behind families, friends, children, and peoples whose lives are forever changed. Every text message that once represented excitement and romance became evidence projected onto a courtroom screen. It's a sobering reminder that private choices can one day become public exhibits. And that's exactly why I end every episode the same way. Marriages belong in family court, not criminal court. Divorce court will do. Let's talk about the Slayer statute for a moment. Here's where this story takes an incredible turn that will make your jaws drop. You would think that if you are arrested and facing a first-degree murder charge for poisoning your husband, you'd be entirely focused on staying out of prison. But in this case, the battle lines were drawn in two different courtrooms at the exact same time. While criminal prosecutors were putting together their murder case, the defendant actually went on the offensive. Through her civil attorneys, she filed a motion in probate court against her husband's late estate. Her argument? Standard contract law. She filed a motion demanding that the estate immediately hand over the millions she was owed under the prenuptial agreement. Her legal team essentially told the court she is innocent until proven guilty. As of right now, she is his legal widow, and under the terms of that prenup, that money belongs to her. Deliver the funds. It is a bold, high-stakes legal play, and it forces the husband's family to throw up a defensive shield of their own. So, how does a family stop an accused murderer from walking away with the victim's fortune before the criminal trial even starts? They invoke a powerful legal doctrine known as the Slayer statute. Here's how it works. On a practical level, and why the defense's motion hits a brick wall. The civil phrase. When a family raises the slayer statute, the civil judge will typically stay or indefinitely freeze the civil lawsuit. The court essentially says, we are putting a giant pause button on this money. No one gets a dime until the criminal jury speaks. The legal fiction imposes a penalty. If the criminal jury finds her guilty of murder, the civil court triggers a bizarre but brilliant legal fiction. The law officially pretends the murderer predeceased her victim. The final bypass, because she died first in the eyes of the probate court, she has completely crossed off the prenuptial agreement. The inheritance entirely bypasses her and goes straight to his kids, his siblings, or his estate. So while the defense tries to use the civil court to fund their fight, the slayer statute ensures that if you pull the trigger or spike the drink, you legally write yourself out of the payoff. So those that know me know my favorite line is, read the writing on the wall. But here's the hard truth, and we have to talk about this. Protecting your assets is not the same as protecting your life. Sometimes we convince ourselves things will get better. We minimize what's right in front of us because we love the person holding the pen. We hope tomorrow will be different than today. We build legal walls to protect our money, but we keep our physical doors open to the threat. That is why I always tell you, don't just see the red flags. Read the writing on the wall. The writing on the wall is the pattern. Patterns tell the story long before a tragedy does. If someone repeatedly violates your trust, exploits you financially, and leaves you questioning your very safety, do not dismiss those moments as isolated incidents. Step back, look at the entire canvas, because sometimes that writing on the wall is trying to save your life before it's too late. The loudest warning isn't always the one that saves you. It's the quiet one you explain away. The unexplained withdrawal, the secret loan, the changed beneficiary, the promise that never came true, the feeling that something just isn't right. Those moments weren't random. They were the writing on the wall. And no legal document can protect you from what you refuse to face. Prenups, trusts, estates, estate plans, they can organize assets, but they can't fix deception. They can't replace common sense. They can't make someone honest. At some point, the protection isn't paperwork, it's leaving. Don't spend years explaining away what your instincts already understand. Read the writing on the wall. The writing on the wall rarely appears overnight. It's written one lie at a time, one secret at a time, one betrayal at a time. The question isn't whether the signs were there. The question is whether we choose to read them. Let me leave you with one personal thought. After years of practicing family law, if it were me or one of my daughters, I wouldn't encourage signing a prenuptial agreement before asking some very hard questions. Because if I'm taking the risk of pregnancy, childbirth, stepping away from my career, sacrificing my health, my body, my earning capacity in years I'll never get back, then you're taking a risk too. A prenuptial agreement can protect your assets. It cannot protect your marriage. Character does that. Don't sign away tomorrow trying to secure today. I'm Joni Solomon. This is On One. Love hard, leave smarter, and remember, divorce court will do.